I'm Robert George. I am the McCormick Professor of Jurisprudence and Director of the James Madison Program in American Ideals and Institutions here at Princeton. And it's my very great pleasure to welcome you to our 2025 Herbert W. Vaughan Lecture on America's Founding Principles. For those of you who are not familiar with the Madison Program, we're a program dedicated to exploring enduring questions of American constitutional law and Western political thought. If you'd like to learn more about our activities, please visit our website at JMP, James Madison Program, jmp.princeton.edu. And you can follow us on X, formerly Twitter, at the handle @Madison Program. Please visit our website. You can sign up there for our newsletter, and I hope you will. You can subscribe to our Madison's Notes podcast, and you can learn more about our upcoming events. We begin the Vaughan Lecture by remembering our great benefactor, my great friend, Herbert W. Vaughan, known as Wiley Vaughan, partner at the law firm of Hale and Dorr, leader of the firm's very distinguished commercial and industrial real estate department. If any of you are familiar with the skyline of Boston, the John Hancock Tower and the Prudential Tower, Wiley built that. And I got to know him when I was working for the guy who was working for the guy who was working for the guy who was working for Wiley at the law firm of Hale and Dorr, fresh out of law school. My job was to get the elevator permits for the new buildings that were being built. But it generated not only some very welcome cash for a impoverished recent student, but also one of the great friendships of my life with Wiley, who was just a gem of a human being and very dedicated to America's founding documents, America's founding principles, and the American civic order. Well, Wiley was the very best of true patriots, and he subscribed to James Madison's teaching that only a well-instructed people could be permanently a free people. So he dedicated much of the wealth that he accumulated to supporting education, and especially civic education. He was a graduate of Harvard College and Harvard Law School, but he became somewhat disaffected from Harvard, and we at Princeton became the beneficiaries of that disaffection. And the fund that he established to support civic education here supports this annual lecture. Wiley asked that at all lectures, all Vaughan lectures, we open the ceremonies by reading a statement from him. Wiley's been gone now for, I guess, close to 15 years, but we have his own words as to why he endowed this lectureship, and let me read them to you. I, Herbert W. Vaughan, have endowed this lecture series at Princeton to promote and advance understanding of the founding principles and core doctrines of American constitutionalism. What Alexander Hamilton said to the Americans of his day remains true for Americans of every generation. And here he quotes Hamilton from the very first Federalist paper. Quote, "It seems to have been reserved to the people of this country, by their conduct and example, to decide the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force," unquote. Wiley then returns to his own words. "In my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you," and here Wiley speaking to all of us, "may you be guided and inspired by their genius as you meet the challenges of the present day." And I know just how pleased Wiley would be that our 2025 Vaughan lecturer is Professor Daniel Mark. Dr. Mark is Associate Professor of Political Science down the road at Villanova University. He was appointed by successive speakers of the United States House of Representatives to the U.S. Commission on International Religious Freedom, which he served on for 4 years. including a term of service as chairman. His book, The Nature of Law, subtitled Authority, Obligation, and the Common Good, was published in 2024 and received the First-Time Author Award from the University of Notre Dame Press. At Villanova, Dr. Mark is a faculty fellow of the Matthew J. Ryan Center for the Study of Free Institutions and the Public Good, and of the Eleanor H. McCullen Center for Law, Religion, and Public Policy. He also holds the rank of battalion professor in Villanova's Navy Reserve Officers Training Corps unit. I want to say what a personal pleasure it is for me to welcome Danielle back to Princeton. I say back because Danielle was here and was my student here both as an undergraduate and a doctoral student. I often say that my sense of my own vocation as a teacher is to try to form the young men and women entrusted to my charge to be determined truth seekers and courageous truth speakers. No one has fulfilled that vocation as profoundly as Danielle Mark has. So I'm glad to introduce my friend, my student, Danielle Mark, for his lecture, The Nature of Law, Authority, Obligations, and the Common Good. Please join me in welcoming Danielle Mark.
Good afternoon. Good afternoon, everyone. Good evening, really, I guess. It's probably dark by now outside. Thank you so much to everyone for being here. Thanks especially to the entire team at the James Madison program for putting this together, and especially to Christy Johnson, who actually had to deal with me. It's a special honor and delight for me to be here after having spent many of the best years of my life at Princeton, as an undergraduate, you just heard, as a graduate student, and as a James Madison program visiting fellow. Even after being away for a while, it is the place that feels most like home to me. And now being here to give the annual Herbert W. Vaughan Lecture on America's Founding Principles, you honor me too greatly. Anyone who knows me knows I owe special thanks to Professor George. Everything I am intellectually, professionally, except for the flaws, is down to Professor George. If everything good that I am is from Professor George, everything I do is for my children. And so being back home in Princeton, where all of my academic work began, if I might, I would like to dedicate this lecture to them with some words that mean a lot to me from the great man of letters, Dr. Seuss, and his very socially conservative Horton series. Did he run? Did he not? Horton stayed on that nest. He held his head high and he threw out his chest, and he looked at the hunters as much as to say, "Shoot if you must, but I won't run away. I meant what I said, and I said what I meant. An elephant's faithful 100%. The thesis of my book, The Nature of Law, is that law is a set of commands oriented to the common good. The thesis of my talk, my aim today, is to argue that HLA's legal positivism makes one or more of his core contributions to analytic jurisprudence effectively unintelligible.
You mean HLA Hart?
What did I say?
HLA.
HLA Hart's legal, thank you. That'll be very important later. HLA Hart's legal positivism makes one or more of his core contributions to analytic jurisprudence effectively unintelligible. For the main part of my talk, I'm going to keep it academic and technical, which I know is what everyone wants to hear and why you came here in the first place. Later, I'll offer some brief remarks on why this might matter for our current political moment. I want to get to Hart by way of the other towering positivist of the post-war 20th century, Joseph Raz. As I've argued previously in the American Journal of Jurisprudence, Raz's account of the authority of law fails. In the normal case, according to Raz, law is authoritative when it requires that which the subject ought to do anyway. This means that in the normal case, there is only an obligation to obey when the reasons behind the law apply. Let me get into that in a bit. I like to joke that legal philosophers mainly care about two kinds of law: traffic laws and Nazi law. So let's talk about what I call the case of the mythical traffic light. You may have to imagine yourself a little bit west of here, somewhere in rural New Jersey perhaps, but imagine coming to a traffic light in the middle of the night, in the middle of nowhere, with a clearly illuminated view in all directions and no one around. There are no cars, pedestrians, animals, or police. What do? Do you stop at the light? And by stop at the light, I don't just mean stop and then go, but stop and wait until it's green before going. To be clear, I am not asking the psychological question of what motivates you, as in what are the reasons you personally would stop or go. People like to raise their hands, and sometimes in a maybe less formal setting, people like to raise their hands and tell me what they would do and why they don't care about the light or something. And I'm not asking either the sociological question about what most people would do. I am asking the philosophical question, and specifically the moral or ethical question of what is the right thing to do. Do you have an obligation to stop at the red light? And by obligation, I do not mean a legal obligation, which I am presuming, though that may be an interesting question in its own right, but a moral obligation. The reason for examining the case of the mythical traffic light and the appeal of traffic law examples more generally is that the case provides a ready example where there is no reason to obey the law other than the fact that it is the law. By stipulation, we have ruled out other considerations for stopping at the light. Usually, one would have reasons to stop at the intersection, even if there were no obligation to obey the law, or even if there were no traffic light at all. Even in the absence of the law, or the absence of any law, you can't recklessly plow through a busy intersection. In this way, we can see, and it is important to see this, that I am not even remotely claiming that traffic laws and similar are arbitrary or disconnected from morality. Rather, these laws are rooted in moral principles, but the specifications of the law are not rationally required. In the case of the traffic light, the law aims at promoting safety for motorists and pedestrians while balancing safety with the important, if instrumental, good of efficiency. That is, the efficient flow of traffic through the intersection, allowing people to get through the intersection without unreasonable delay. Although the law is rooted in morality, no one could reasonably act without due regard for safety and efficiency. The specifications of the law are rationally underdetermined. This is because there is any number of solutions we could bring to bear on the problem of the intersection. We could have a traffic light, or a stop sign, or a yield sign, or a roundabout, or in America, a traffic circle, or nothing at all, leaving people to exercise due care without any particular instructions about how to do so, which would not, in the absence of the instructions, absolve them of their obligation to exercise due care. The specifics are left to what Aquinas called determinatio and Blackstone called matters of indifference. There is no single correct answer, and the solution chosen by a particular community in a particular context is left to the judgments of prudence, within the parameters set by the broader moral principles. What I've said about the traffic light is true of traffic laws in general. The specific solution adopted to the problem, say a specific speed limit or which side of the road to drive on, does not derive from any inherent moral obligation to stay below 55 miles per hour or to stay on the right side of the road, but instead results from the prudential balance of competing goods. This is unlike laws prescribing, say, murder, where the specific performance, or non-performance in this case of not murdering, is rationally required. One needs to refrain from murdering regardless of what the law says or whether there even is a law. But one need not stop at the intersection, much less stop for a designated amount of time, in the absence of a red traffic light and in the absence of other reasons to do so. In the case of the mythical traffic light, we have a situation where the reasons behind the law do not apply because there is no reason to stop other than the say-so of the law. Again, by stipulation, we've ruled out all those other factors. Therefore, if there is an obligation to obey the law, it must be because of something in the law itself, not the reasons behind the law. To formulate it as a question, does the authority of law depend on the reasons behind the law obtaining in that situation, or is there an obligation to obey the law just because it is the law? Unlike with laws against murder, as I said, where the reasons always obtain, we can use traffic laws to test whether the obligation to obey the law applies when the reasons behind the law do not apply. So is there an obligation to obey the law because it is the law? Well, probably. In seriousness, I do propose in the book that the answer is yes, but you'll have to read the book to find out why. In arguing that there is an obligation to obey law qua law, or a prima facie obligation to obey the law, I am rejecting the prevailing notion in the field, articulated by Raz, but shared by many others. But in order to make my way to my own view, and I will give you the answer, let me turn to a prominent question raised by the sort of position I am advocating, which allows us to get to that other sort of law I was mentioning, Nazi law. Why is Nazi law a problem for my position? Well, put simply, if there is an obligation to obey the law just because it is the law, does that mean there's an obligation to obey Nazi law? Hold on to your hats if I get to my answer on that one later. We might appeal to the ancient maxim that an unjust law is no law. Nazi law is unjust law, therefore Nazi law is not law. If unjust law is not law, then there is no problem of an obligation to obey an unjust law just because it is the law, because an unjust law is not the law. But here's Hart's critique of that solution. Of course there is law in Nazi Germany. Any honest observer, say Ketanji Brown Jackson's Martian arriving here from another planet, sees law in full operation. To coin a phrase, if it walks like a duck and talks like a duck, it's law. As Scott Shapiro puts it in his book Legality, to say otherwise is to deny a truism. That is, the failure to identify law where it clearly exists is to deny a truism. I won't delve into Shapiro's book here, but I'll just flag that I think his work exemplifies a claim I've made about the way in which theories building on Hart and also on Raz fail, in large part because they are building on a flawed foundation. Hart and Shapiro have their view because they are positivists. This means they believe we can define, describe, identify law without reference to normative criteria or morality. For older positivists, the non-normative criteria for identifying law had to do with the attachment of sanctions or punishment to a directive. For Hart, the non-normative criteria are, quote, rules based in social practice, or what Hart calls the rule of recognition. What makes law law is its conformance to a set of non-moral criteria that constitute the way or ways in which law is made in a given political community. So, for instance, a federal law may be so when it is passed by majorities of both houses of Congress and signed by the president. Per positivism, we can recognize this as law without reference to the content of the law, as long as it meets the procedural requirements and any relevant constitutional restrictions. Therefore, Nazi law is law, whether it is just or unjust, just as American law is law, whether it is just or unjust. Because Hart is not arguing there is an obligation to obey the law just because it is the law, he doesn't have the problem of Nazi law. I'll say shortly, though, why I think this creates another problem for him. But unlike Hart, I do have the problem because for Hart, either I have to deny the truism, deny the reality of law that exists right in front of my face, that Nazi law is law, or I have to admit the truism and concede that there is an obligation to obey Nazi law just because it is the law, even though it is unjust. As it happens, I think the best one-stop shopping rejoinder to Hart's and others' positivism is John Finnis's article, Law and What I Truly Should Decide. In that piece, Finnis argues that justice is the very purpose of law, and the concept of law is unintelligible without reference to justice. Justice is, you might say, part of the nature of law. Finnis explains that one can put a label that says medicine on a bottle of poison, but that does not make it medicine. So too with law and justice. You can call something law, but if it intrinsically advances injustice rather than justice, it is no more law than a poison labeled medicine that promotes sickness rather than health. But instead of focusing on this external critique of Hart, i.e. why positivism is just wrong, I want to draw out my internal critique of Hart, showing why Hart's theory is internally inconsistent, or at least highly unstable. Hart's 1961 work, The Concept of Law, inarguably had a huge impact on analytic jurisprudence. One of his central contributions to the field was his association of the concept of law with obligation. As I mentioned, older positivists, here I'm thinking, for example, of John Austin or Jeremy Bentham, strongly associated law with the attendant punishment or sanctions. Hart elucidates this by comparison to a mugger. If a mugger points a gun at you and demands your wallet, you are obliged to turn over your wallet in the sense that if you don't, you can expect negative consequences. You wish to avoid those consequences, so you turn over your wallet. This is what it means to be obliged. And this is how Hart thinks Austin and Bentham see following the law. But being obliged for Hart is different from being obligated. If you somehow manage to create a diversion and escape from the mugger unharmed without turning over your wallet, no one would say you had done anything wrong in failing to turn over your wallet. No one would say you had failed to fulfill an obligation. There was no obligation to turn over your wallet to the mugger. You were obliged to do so, but not obligated. But Hart says that the old positivists are wrong because this is not how people relate to the law. They don't relate to the law the way they relate to a mugger. People relate to the law as though they are not just obliged, but obligated. They relate to the law as though it imposes an obligation upon them such that if they do not comply, they and we might say that they do something wrong in not complying. With this distinction between obliged and obligated, Hart develops his distinction between what he calls the external and internal points of view. Happily for us, Hart develops this further by reference to a traffic light. From the external point of view, again, maybe Justice Jackson's Martian arriving from another planet, this time viewing the intersection from above in an unidentified flying UFO, one can see the red light as a sign that drivers will stop. A sign that drivers will stop. From this perspective, the law is merely a prediction of regularized behavior, which description, the prediction of regularized behavior, will be recognizable to those familiar with legal realism, and especially Oliver Wendell Holmes's famous discussion of law. Hart, however, believes that the external point of view misses something critical about the law, namely that drivers do not take the red light merely as a sign that cars will stop, but a signal to stop. Again, not merely a sign that, but a signal to. Drivers take the red light to mean that they are supposed to stop, not just that people will stop. The internal point of view reveals that people treat the law as a standard against which to measure their behavior and the behavior of others. This is the sense of obligation that arises from the law and not from the mugger. Failure to comply with the law is accompanied by a judgment of having done something wrong, having failed to fulfill an obligation. To summarize, for Hart, one of the defining features of law, if not the defining feature of law, or what distinguishes law from coercion, which is so critical, is that law carries with it a sense of obligation. Now here's the problem. Because Hart is a positivist, he maintains, as I explained, that law can be defined without respect to morality, or identified without reference to normative criteria. But if we can identify law without reference to normative criteria, if law can be law, whether it is just or unjust, in what sense can we say that law necessarily carries a sense of obligation? To be clear, if Hart were to cast his lot with the older positivists, this would not be a problem. If law obliges rather than obligates, that is, if I have an obligation to obey the law only in the sense that I will be punished if I do not obey, then it does not matter if we identify law without reference to normative criteria, because all we are saying is that the authority has the power to punish me for non-compliance, which of course can be true whether the law is just or unjust. Sanctions can attach to my behavior without reference to legitimacy or justification or anything of the sort. Yet Hart explicitly and decisively rejects this when he declares that the law is not like a mugger. So on one hand, Hart insists that obligation is a defining feature of law. On the other hand, Hart says we can identify law without reference to normative criteria. Therefore, we must ask, where does the sense of obligation come from? If people do have an obligation to obey the law, where does it come from? Can there be an obligation? Where does the obligation come from? Can there be an obligation to obey the law regardless of the content of the law? How can we make sense of a content-independent obligation to obey the law? And if people do not have an obligation to obey the law, why do they treat it as though they do? Why, from the internal point of view, do they treat the law as a standard against which to measure their behavior? It is too much of a stretch, I believe, to say that no one has an obligation to obey the law, yet everyone believes himself or herself to have one. And I do not believe we can say consistently with Hart that everyone believes there is no obligation to obey the law, yet acts as though there is one for prudential reasons. That would not satisfy, in my view, the obliged, obligated distinction. To recall the issues surrounding Nazi law from earlier, Hart's positivism means that he does not have the problem I have. He can say that Nazi law is law without running into the maxim that an unjust law is no law, because he thinks that law can be law without regard to whether it is just or unjust. But this point itself shows how incoherent it is for Hart to turn around and say that obligation is a defining or even distinguishing feature of law. Remember, without an obligation to obey, the authority of law is reduced to coercion. Law is like a mugger. Hart wants to maintain that law is not like a mugger. People treat law as though they have an obligation. And he wants to maintain that law can be identified without reference to the very normative criteria that would allow us to account for that obligation. This is a fundamental flaw that runs all the way to the bottom of Hart's theory and dooms the theories built off Hart, such as Shapiro's, as I mentioned earlier. Admittedly, I am not the first to notice this problem. The point was made much earlier and better by that great man of letters I quoted earlier, Dr. Seuss. I assume I am the first Vaughan lecturer to quote Dr. Seuss, not once, but twice, so I hope Professor George will forgive me, and I especially hope that Wiley Vaughan himself will forgive me and continue to intercede in heaven on all our behalf. But in his majestic 1973 tome, Did I Ever Tell You How Lucky You Are?, he, Dr. Seuss, writes, and this is verbatim from page 13 for your notes, just suppose you were poor Herbie Hart, who has taken his thromdimulator apart. He never will get it together, I'm sure. He never will know if the gick or the gore fits into the scrux or the snux or the snore. Yes, ducky, you're lucky you're not Herbie Hart, who has taken his thromdimulator apart. And here's the illustration of Herbie Hart and his disassembled thromdimulator. And yes, the H in HLA Hart, now that I've got the name full, stands for Herbert. So there is little room for doubt about to whom Dr. Seuss was referring in this devastating takedown. 1973, remember, so not too long after the concept of law was published. In short, if we separate law and morality, we cannot have obligation as a necessary feature of law. And if obligation is not a necessary feature of law, then Hart's insight about the internal point of view can't be right, in which case maybe people really do relate to the law as they do to a mugger, or perhaps in some way that isn't like a mugger, but also isn't consistent with Hart's internal point of view. As it happens, I think Hart is likely right about the internal point of view and wrong about his positivism. So the answer runs in the opposite direction. But we have to answer for Hart, who can't take our route of simply rejecting positivism. One possible response to this is that Hart does not need to hold that morality is part of the definition of law, i.e. that people have an obligation to obey the law, only that people understand themselves to have an obligation to obey the law or in some way treat the law as though it obligates, even though it does not, or it does not necessarily. But this is a very difficult position to sustain. Naturally, we would ask why people treat the law as obligatory. The normal response would be because it is obligatory. But that's ruled out here as part of our attempt to reconcile the internal point of view with Hart's positivism. So why would people treat the law as obligatory when it's not? I suppose one possibility is mass delusion. Everyone thinks there's an obligation to obey the law, but there isn't. But if that's what explains the internal point of view, then I think it's not the revolutionary insight we thought it was, to say the least. Alternatively, maybe people don't believe they have an obligation to obey, but as I suggested before, they just act as though they do. But then naturally we would ask why they treat the law as obligatory when they don't believe it is. To be sure, there could be any number of prudential reasons to treat the law as obligatory even if it is not. Many of those reasons could even be very good reasons. Recall, though, that Hart's internal point of view suggests that people treat the law as a standard against which to measure behavior in the sense that we could judge someone who falls short of that standard as having done something wrong, assuming intent and so forth. And to be absolutely clear, this does not and cannot mean having done something wrong merely in the sense that there are or might be negative consequences, as with a mugger or anyone with coercive power over you. From my perspective, none of this can add up to people treating law as though they have an obligation, at least not in the sense that would support Hart's obligated distinction. In a way, this last point speaks for itself. Following the law for prudential reasons is not the same as being obligated. If people are complying with the law, and I say complying because I don't even like using the word obeying in this context, if people are complying with the law for prudential reasons, no matter how reasonable, they don't treat the law as a standard against which to measure their behavior, except insofar as complying allows them to avoid the consequences of not complying, whether the loss of certain advantages or the gain of certain disadvantages, which is precisely the opposite of what Hart is insisting on. We can see this in the simple test case of whether they follow the law in situations when prudence cuts in the other direction, and the traffic light gets at this. If they don't follow the law when the cost-benefit analysis says otherwise, then we can't say they consider themselves to be obligated, to have an obligation to obey. Excuse me. Allow me to approach my critique of Hart from one more angle. Hart famously characterizes his efforts in the concept of law as descriptive sociology. This is in line with his positivism. He's not arguing about the morality of law, or so he says, but instead observing facts about the law and people's practical relationship to it, how they act. I would break down Hart's approach to the law into three questions. First, do people feel they have an obligation to obey the law? Second, why do people feel they have an obligation to obey the law, if at all? Third, do people in fact have an obligation to obey the law? And if so, what is its ground? Hart's claim to descriptive sociology gets him off the hook for the third question. Hart seems to be answering the first question, do people feel they have an obligation, in the affirmative. People do take the law to be obligatory. But I think Hart's positivism makes it very hard for him to answer the second question about why they do so. Why do people treat the law as obligatory when it is not necessarily so? As I said earlier, for Hart, the criterion for identifying law is the rule of recognition. Laws, in Hart's terminology, are, as I said, rules based in social practice. That is, within a given community, there are universally or near universally accepted procedures for generating laws, which again can be anything from a vote by the legislature and a signature by the executive to a parchment declaration by the monarch sealed with the wax imprint of his signet ring. The directives generated in conformance with these procedures that follow the rule of recognition are recognized by everyone as law. And they are recognized by everyone as law whether or not those doing the recognizing are keen on the content of the law. If you'll forgive the glibness, the rule of recognition is a way of saying that's just what we do around here. We can identify X as law because X came to be by the generally accepted processes for creating law in our community. But then we are required to ask why people feel obligated to that. Assuming no dispute at all about the rule of recognition within a given setting, what is it? What is the obligation to obey laws identified by conformance to laws identified by conformance to it? People can have many good reasons to comply with the law, but do they have an obligation to obey? If we ask people, do you have to do things a certain way because that's the way we've done them here all along, what would they say? Are you obligated to follow rules that everyone is following just because everyone else is following them? It may be convenient, or even more than convenient, to do what we do around here, but in what sense could we say people are obligated to do it rather than just buying into an arrangement that suits them? To the point, would they be doing something wrong? Or in what sense would they be doing something wrong if they did otherwise when what we do around here didn't suit them? There are many reasons consistent with Hart's theory that people could give as to why they comply with the law. But Hart's positivism makes it impossible for them to account why they have an obligation to obey. More precisely, in some cases they could give such an account, but there would have to be at least some other cases in which they could not. Otherwise, we would have no case in which we could identify law without reference to normative criteria. To claim that this is just a coincidence, that it is just a coincidence that there is no case where the rule of recognition doesn't happen to include normative reference, like the possible claim that the internal point of view is the product of a mass delusion, is too much to bear. In other words, I am arguing that there cannot be a non-normative account of the obligation to obey the law, and it also cannot be that there are merely by chance always additional normative factors attaching to the non-normatively identified law. My thesis, contra mundum, is that the right way to define law is as a set of commands oriented to the common good. As I say this, I am mindful that I don't think I am improving much on Aquinas' definition of law as an ordinance of reason for the common good made by him who has care of the community and promulgated. There are two parts to my definition of law. In the first part, law is a set of commands. I am going back to an older way of thinking about law as commands. Hart eschewed the terminology of commands in favor of rules, arguing that many laws are not commands. Although they may not otherwise agree with him, Hart, I think, finds allies here among common lawyers, for whom the paradigmatic case of law is not a command from a sovereign. For my part, I favor the term command precisely because it best captures the notion that law is necessarily linked to obligation. Commands, whether or not they actually obligate, certainly mean to obligate. Hart prefers the term rule in part because it does not carry that sense, or carries that sense much more weakly, and thereby allows him to include both duty-imposing rules and power-conferring rules in the category of law. The argument that power-conferring rules, like duty-imposing rules, also intend to obligate does Hart no favors, because that line of reasoning bolsters my argument, also contra mundum, that power-conferring rules are in fact a species of duty-imposing rules. The smaller the distinction between duty-imposing and power-conferring rules, the less Hart can justify picking rules over commands. This distinction between types of rules risks taking us down a fun but tangential rabbit hole, so I will just return to my main point here. Law as command, in my view, is the best way to capture Hart's worthwhile insight of the internal point of view that law is necessarily characterized by obligation. Again, perhaps not all laws are commands, but command is still the central case of law. I remain open to persuasion on this by our common law friends, but either way, I am confident that command is the best way to describe the form of law if obligation is a key feature of law, as Hart says. Also in the first part, I define law not just as a command, but a set of commands. This allows me to explain how there can be a prima facie obligation to obey even an unjust law. It is because the obligation to obey the law just because it is the law inheres in the legal system as a whole. Justification is assessed at the level of the system. So if the legal system as a whole is justified, then each law within that system carries a defeasible obligation to obey. The legal system can be just even while an individual law within that system is unjust. The overall obligation to obey the law in that situation attaches to each individual law, which must be followed absent a conclusive reason to disobey. In the second part of my definition, law as oriented to the common good, I am arguing that law must be connected to justice. This is, it will be no surprise by now, a full rejection of Hart's positivism and an endorsement of Finnis's argument that law without justice is like medicine without healing. It simply isn't the thing it claims to be. Or, to fulfill my contractual duties with my home institution, the Augustinian Catholic Villanova University, Charlie, tell them I said the thing. As St. Augustine said, kingdoms without justice are great robberies. Law, correctly understood, is unavoidably normative, and the normative force of law comes from the legal system's orientation on the whole to the common good. I prefer the nature of law over Hart's the concept of law because the term helps us to see that law does indeed have an essence and, like other natural institutions, is what it is no matter the efforts to redefine it. While it's a separate point, I should at least note that rooting the authority of law in its orientation to the common good means that justified authority does not require consent. This topic goes beyond the scope of my talk today, so I'll offer just two quick nuggets to motivate my claim. First, it is uncontroversial among right-thinking people that we have lots of moral obligations that come to us without consent. Second, consent theories don't work anyway. Thank you, Dave. But let me also acknowledge that this is at least in part an area of good faith disagreement among natural law scholars, so I want to leave this open for future debate. To return to the overarching point and state it in the boldest terms, Hart and Raz are extremely influential, and their work and the work of those who build on them represent the dominant school. But that work is flawed to its core. Moreover, To the extent that non-positivists take on parts of their framework, and they do, such as laws as rules and the distinction between duty imposing and power conferring rules, which I have mentioned, or, the distinction between first order and second order reasons, which I have not mentioned, they err. While this is also not our topic today, I'm quite skeptical of the distinction between first and second order reasons, though I am not aware of anyone who agrees with me on this. On that last point, because I have not otherwise mentioned it, I'll just flag that my theory of law as I've explained it, suggests that at least in some cases, one weighs legal obligation, i.e. the moral obligation to obey the law, against other competing moral obligations, as though all of them, the legal obligations, the moral obligations, are first, as though they are all first order obligations, notwithstanding the conventional view, which follows Raz, that legal obligation provides a second order reason. And I know that won't mean much to most people, but I've just dropped a bomb, so future paper to come on this. But sticking with the heart of this paper, let me turn to two practical-ish implications at the intersection of ethical and legal theory. And so I'm leaving the weeds now for something normal people might care about or think about. In the concept of law, Hart discusses the war crimes trials held for Germans after World War II, so back to Nazi law and the Nazis. Hart raised this as a vexed question because those trials stand as examples of people being tried for acts that were legal at the time they committed them. I concede that there is something vexing about trying people for acts that were legal when they committed them. But not on Hart's terms, very vexing. For Hart, the fact that the acts were legal really shouldn't mean much. If we can identify law without reference to normative criteria, then we can infer nothing about the legitimacy of the law from the validity of that law. Identifying law with reference to non-normative criteria, we can find laws to be valid, that is, we can find laws to be laws, without finding them to be legitimate. So if the fact of something being law means only that it came to be in accordance with the rule, of recognition, and if the rule of recognition tells us nothing about whether the law is just, and therefore whether it is justified, then the quandary doesn't seem that deep. People committed bad acts that were legal when they committed them. So what? That by itself doesn't or shouldn't mean much, if anything, because on Hart's term, the fact of something being law cannot itself generate an obligation to obey. On my theory, things look different. If there is an obligation to obey the law just because it is the law, then the people who committed the acts when they were legal were under a prima facie obligation to obey the law. On some level, there was a moral obligation to obey the law. This does not mean that there were not better reasons to disobey the law than to obey it. On a reasonable assessment, the reasons against obeying may very well have defeated the reasons in favor. But at least the dilemma gets off the ground when we have competing moral obligations on both sides of the equation. A second implication. On the standard account, civil disobedience entails accepting the punishment that accompanies breaking the law. But why accept the punishment? There may be prudential reasons for doing so. It would be hard for Martin Luther King to be Martin Luther King on the lam. But the fact is that this is a default feature of civil disobedience. The fact that this is a default feature of civil disobedience suggests that there is a principled reason as well. I would argue that the inherent normativity of law, which generates the prima facie obligation to obey, means that when someone breaks the law, there is a sense in which the person has done something wrong. Again, the reasons for breaking the law may defeat the reasons for following it, but the reasons for following it still exist and are honored in submission to the law after breaking it in an act of civil disobedience. Now let me widen the aperture a bit more and very briefly highlight some contemporary and enduring political implications of what I'm saying. First, to return to the quote from St. Augustine, bonus, kingdoms without justice are great robberies. My thesis is that to earn its name, a legal system must be oriented to the common good. This allows for the possibility, maybe inevitability, of some injustices in the law, in an otherwise just legal system. But it also means that if the legal system as a whole is not sufficiently oriented to the common good, then it no longer possesses justified authority. I do not think it would be a fruitful exercise to attempt to draw an exact line, but there would be clear examples on both sides of the line. At some point, a state becomes a tyranny. This is not a partisan point, or better yet, it is an equal opportunity partisan point. We are in an era in which both sides have attacked the enactments of the other side as illegitimate. Ironically, given the context of what I'm saying, maybe many of these accusations do come in the form of procedural objections, i.e. claims that what is being deemed law does not conform to the rule of recognition. We see this in complaints about the auto pen or other exercises of executive power, including conflicts between the executive and the judiciary. And without in any way minimizing the importance of procedural requirements, we can also recognize that the real fight is over the substance of the policies, not the processes. Questions about when a state becomes a tyranny and the limits of justified authority are real and enduring questions. Second, and closely related, is the notion embedded in my thesis that politics and law, rightly understood, are about the common good. Law, in my definition, as you heard, is a set of commands oriented to the common good. Political contestation, then, is a competition between rival conceptions of the common good, or sometimes more narrowly, rival proposals for how to advance the same conception of the common good. This is a point that takes us all the way back to the opening scenes of the most important work in the history of political thought, Making Men Moral, Plato's Republic, namely that politics is fundamentally about justice, not power. Looking around these days, one could be forgiven for thinking that our republic is only going to survive if we recapture the idea of politics as a contest between competing visions of the common good and not simply as a numbers game, namely a contest to see which side has enough support to force the other side to submit to its will. These days, though, we have to wonder whether the idea of politics as competing views of the common good is only prescriptive and not descriptive. It is a fine aspiration to envision politics in this way. If it were true, or at least if we believed it were true, it would be easier to see our political opponents as countrymen instead of enemies. But what if it isn't true? What if the other side doesn't offer a competing vision of the common good and is just after power? Or what if the other side's supposedly good faith vision of the common good is so unjust that it can't be tolerated as an alternative? In that case, say the critics, it would be naive and foolish and even dangerous to treat politics as friendly competition. Maybe it really is a death struggle. I maintain that this is one of the important tasks for Professor George and his allies today, namely to answer the critics who say that we don't know what time it is. In my view, the beginning of the answer is that one can know what time it is and still have principles. If the hallmark of knowing what time it is means being willing to do anything to win, then count me out. We must remain steadfast in our commitment to the teaching of Plato and the natural law and the church that it is better to suffer injustice than to commit it. But that tells us more about what isn't the response to the breakdown of politics than what is the response. And I think that some sort of affirmative articulation is necessary to rescue the next generation of conservatives from a certain Thrasymachine or otherwise nihilistic right-wingism. So, on that hopeful note, I thank you for your kind, extended attention and welcome your questions.
Okay, very good.
Here,
yeah, right here. Yeah.
Here? Okay.
The floor is open. Yes, Dimitri.
Great, thanks so much. I really enjoyed the talk. So
Thank you. Oh. For posterity, into the microphone.
Thanks. I really enjoyed the talk. So I have a question about the common law, or more specifically, I guess I have a question for you on your account. How do you characterize what judges are doing who say that they are not, that when they're applying the common law, they are discovering a requirement of the law? They're not issuing a command on their own. So it seems like your options would be to say that, I guess with the legal realists, the judges are in fact the relevant commanders. They're just issuing a matter of law, or they're agents of some commander. But then, with the common law, we don't really have an original legislative command for much of what the judges have created or discovered. So how would you characterize what the judges are doing, and who would the relevant commander be?
Yes, so great question. So great question, and I think the question is better than any answer I might have, actually. But and this is why, I flag I definitely need. There has to be a future. I mean, if I can do it, a future part where I just think through all the implications of this as it relates to common law. Because I also do want to say, partly under the influence of the incredible law professor Adam McLeod, who's now down at St. Mary's, huge fan of his work. I'm very sympathetic to the arguments of the common lawyers, and so I don't think I can just dismiss it. Like I said, very open to persuasion. But with respect to your question, so I'd prefer. Given the option, I'd prefer not to side with the legal realists and just think that the judges are the relevant commanders. In other words, I want to think that common law is a reality and not a fiction in a way. And you're absolutely right that in a way I would prefer to be on the side of saying they are an agent of, right? What they are discovering is the command that exists prior to them. Now, of course, in reality, it may be impossible to locate that command. Now, that may be just because the origin of the commands was lost in time, but I think that would give short shrift to common law, because the reality is that a lot of what becomes common law, I think, in fact, does arrive organically and is not the commands of some forgotten sovereign, right? So in that case, the move that I gestured at here is to say that command is the central case of law. And so there's kind of a spectrum. I don't know what the right way to say it is. That command represents the central case of law, and then common law is still a kind of law, but it's a kind of law in a way that's with reference to the central case. So it's true. So I'm just going to concede. Now, I'm not even going to pretend that there's a command of a forgotten unknown sovereign or something like that, but say that the central case of law is command, and this is kind of an offshoot of that. Now, I know that answer is not going to satisfy Adam McLeod, Jim Stoner, other great scholars of the common law. And again, unlike some of my other claims where I'm steadfast, maybe they're right. But that's my answer: is that law is command is the right way to think about it. And then there are other things that are law, but in kind of a there's still law in terms of obligation, but in terms of the form, kind of in a secondary way. And I'll just say as an aside, I really like my defense of this claim that, which is obviously extended in the book, but that power conferring laws are really a species of duty imposing laws, the way nullity is in a way a sanction, and all the things that Hart thinks is terrible, outdated ways of thinking. But just in that respect, there's a related problem here of trying to locate the duty in a power conferring law. And I think insofar as I treat that satisfactorily, I think I'm on the road to kind of answering your question, but I want to fully acknowledge that that's still an open question.
I think it'd be helpful, before the next question, yeah. I think it'd be helpful, Danielle, if you could just by way of a couple of examples, explain the difference between what Hart calls duty imposing and what he calls power conferring. Well, he says, of course, rules.
Sure. Yeah. So for anyone who's, and I think this is a lot of fun. This is, as much as you thought this was narrow and technical, if I would have done that for the talk, it would have been even, that's fun to do. I once had the privilege of the great natural law scholar also in your school, Richard Eakins, once got to do this in a seminar at Oxford, where it was kind of a room full of people who just kind of doing Hart all day, and that was really great, because then I just had a room full of people throwing rotten tomatoes at me, basically for the objection. But But Hart says that there's this itch for uniformity in the law to characterize all law as duty imposing. He says that's not right. So a duty imposing law is a law like the normal ones, and it could be kind of negative in the sense of, don't speed or don't kill or something like that, or positive in the sense of pay your taxes. So it's a law that imposes a duty. It's a do or a don't. Right, I don't have a podium mic, so I don't need to be over there anymore. So it's a do, and if you don't like me over here, it's your fault because you wander. I learned wandering the room from you. Duty imposing laws are do's and don'ts. A power conferring rule, as its name, kishmo kenhu, it does the thing that it says. It confers a power. So you don't have to get a driver's license, but there's a power conferred. It's kind of an option to do something. That's a power. Or to get married under the law is something that there's no duty to do anything. It's just a power conferred on people by the law. Now, this gets complicated because of what I would call like the second order category of power conferring laws, which is laws about laws, such as like laws about how Congress creates laws. So again, Congress has no duty to pass any legislation, but the Constitution confers upon them the power to pass a law and do it and if they're going to pass a law, the power is specified in the manner in which they must exercise the power. Like vote it, you need a majority of both houses, the signature of the president, and so on. And then Hart argues, well, of course this can't be a duty because a duty would have a sanction. Power conferring rules don't have a sanction. If they fail to pass the law in the right way, like they only get 40% of the vote, the result is not a punishment, just what he calls a nullity. Just the law just fails to come into existence. And again, I have an extended argument about why I can still fit that into the duty imposing model, but that's what that is. And if anybody wants further elaboration or clarification at the expense of being mobbed afterwards by everybody else, you can ask during the Q&A. I think we were here. Yeah.
Hi, thanks for a great talk. And this may be somewhat of an ignorant question since this isn't my field, but could you speak as to how your conception of the law relates to Adrian Vermeule's common good constitutionalism? It is rather broad. Yeah. Right. No, that's fine. I'm going to give a strong non-endorsement of Adrian Vermeule in some respects, in many respects. So one of the things that, in a way, there's a freestanding argument that one has to make in addition to what I've said to point to, I guess, what are like some of the main problems. And I think this, and so the last year's Wiley Vaughan lecturer was Joel Alsea, is that right? So Joel, in addition to being an exceptionally fine human being, is a terrific scholar of the Constitution and natural law, directs a center on that subject at the law school at Columbus Law School at Catholic University of America. Highly recommend his work. So he's one of the people leading, making a good extended natural law argument about this. And so part of what I'm going to say, I'm mentioning this because part of what I would say I learned from him, but he's not alone. A lot of, I think, people in Professor George's school are making this argument. And the freestanding argument is that that laws related to justice and there are requirements of justice and so on, but procedural requirements are also related to justice. And so what that's for normal people, that's to say that laws do need to be just, right? We need to aim for justice in the law. But within that, and the traffic example will actually be helpful here, within the requirements of justice, within the parameters of justice, there are many, many ways to arrange our system, in this case, let's say our constitutional system, that can all be just. So take a simple example from Political Science 101. We could have a presidential system or a parliamentary system. Either one could be just. There's nothing inherent in justice that requires one form of government or the other within the boundaries of justice. However, once we settle through appropriate mechanisms on one of those options, on a solution, then there are very good reasons, obligations, reasons in the natural law to stick with that. And here I would recall Justice Scalia's arguments for originalism, which like sometimes is, well, what's the alternative, right? Is sometimes how I would say it, but to flesh that out a little bit more, it's well, that's what the rule of law is. The rule of law is that we establish certain rules, we establish procedures, procedures and substance and everything, and then we have to adhere to that until we use the also established procedures for changing that. Otherwise, you don't have the rule of law, you have lawlessness. And so I think what, kind of the common good, in part what the common good constitutionalism is saying is that, well, when something comes before an official, and any government official, right? Because it's not really specific to judges, and it happens to be judges, but I don't think it's inherently specific to judges. Comes before an official, the official, the actor, should do whatever is in their power. I'm using the word power advisedly here. Whatever is in their power to advance justice. Without regard to, let's say, the separation of powers or whatever constitutional constraints there might be. And I think that's a huge error because it overlooks the very important reasons which rooted in the natural law, the moral reasons, the moral obligation we have to adhere to the division of power that's been adopted as one prudential option. Now, again, we didn't have to adopt that. We could have adopted a different option that empowered judges to do the things that Adrian Vermeule wants them to do. But having not adopted that, we now have compelling, maybe conclusive reasons not to say that judges can just do whatever they want. And I think Scalia would say that's just like the straight road to lawlessness. Yeah.
Other questions? Yes.
Yes, Daniel, thank you so much for this. So
Thank you.
There are two questions. One is on the idea of command. And I wonder whether you are playing with the ambiguity, because command in Austin obviously is a desire or the will of the sovereign.
Yes.
Whereas you're playing with the word of command, according to Aquinas, as a directive linked to reason, practical reason, and the common good for the one who cares for the community. So on the latter, I think that we all would agree that it's a kind of command because it's a directive, not a command in the sense of Austin. And my second question is about, I obviously, the paper on the seamless web written by Finnis. Yes, and I was struck by your way in which you advance the idea of the general obligation to obey the law. Because also in the chapter on obligation, natural law and natural rights, he agrees with Raz that there is a first point of view judgment there is a third person point of view judgment from the law, and the latter is parasitic on the former. So, and this is all about reasons, but not because it's the law. So you don't obey the law because it's the law, you obey the law because there is a first person point of view judgment that is linked to the respective objective value, and therefore the law is parasitic on that. So it's all about a structure of reasons. And so I'm not quite sure where you are, and I'm intrigued by the position, and I'm very curious about the entire book.
Well, thank you, and thank you for being here. So on the first part about commands, I guess the answer to your question is yes, insofar as those competing definitions of law or notions of law or whatever we're going to call them are whatever we say there, right? So Austin defines commands as this. So I don't think that, I'm not interested in like Merriam-Webster, like there's a dictionary definition of command such that like one of them is, so they can define command however they want. And I think having done that, of course I'm sympathetic to Finnis's view, and I'm tracking that, in my own understanding. But what they would agree on is that, so for Austin, I don't think I'm mischaracterizing what you're saying, where you're saying they're saying. But the difference between Austin and Finnis there is whether it's like necessarily rooted in reason or necessarily oriented to the common good. But either way, like if to use the word directive, right, is to suggest again, like the will of a sovereign, but in this case, it's the will of a sovereign directed at something good. Now, having said that, Finis does not want to, I think, abandon Hart's distinction between like duty imposed. That's why I said contra mundum, like nobody agrees with me. But what I think is very important is that there is a way in which Hart would still not be fully comfortable with either of those, right? So he wants to, and that's what I'm fighting against, right? So Hart definitely is not comfortable with Austin's version, right? The will of a sovereign, and I think that's pretty clear, and hopefully I explained that. But even with Finis, I mean, first of all, I mean, he's not going to appreciate the natural law component. The reason part won't come in as much because the rule of recognition wouldn't necessarily require that. But also, again, depending on how we define command, would be depending on how we define directive. If by directive you mean what I want to mean, as to go back to like the central case of law, that there is there's an authority figure, like Aquinas says, who issues the directive. For Hart, that's not going to be good enough. Right? For Hart will not be able to go there with Finis if we are thinking of directive as kind of command in that sense. So that's really where my argument is, that insofar as Austin and Finis have different understandings of command, I think they're both unacceptable to Hart, and I think Hart's wrong about that. Sorry. Yeah. Oh, yeah. And the second, no, I didn't forget actually. But that's why I paused while you were asking. Is just thinking about grabbing a pen, and I was like, oh, maybe I'll just try to listen. So that's something that keeps me up at night. I will just say that if I am haunted by anything, if I understood you correctly, I think I caught your question. I think that's the thing that really haunts me, and I think that's the thing maybe I need to write about. But I'll try anyway. So there's a way in which, yes, that's what I'm saying, because where does the obligation to obey the law come from? It comes from the obligations we have already to the common good. And of course, we'd have to give like a natural law Finis account. Well, we have obligations downstream from the basic goods. We have moral obligations. Within practical reasonableness, we have the obligation to treat other people's good the same as our own good, again, within that broader framework. And so, sorry, I'm like shortcutting through a lot of things for a lot of people here, I know, to try to address the question. And so I think there's a way in which you could look at my theory and say, wait a second, you've done the same thing. Because what you've done is you've just kind of appealed to reasons at another level, that you also think that obeying the law is about reasons, and obeying the law is about the reasons to advance the common good, or to participate in, or not detract from, or something like the common good. You're smiling at me like I'm going to be in trouble after the lecture, right? So at least we know each other, so that's fine. But I still think there's, right, so Raz gives, the reason I won't give up on my dispute with Raz is because he offers these two kind of commonplace examples. Says that like if you are, so if we have FDA, right, he doesn't say FDA, we have FDA regulations about how a pharmacist can dispense drugs. If the pharmacist knows better than the FDA, the pharmacist is the real expert, and therefore the reasons behind the law, which is that we should rely on the expertise of the FDA, don't apply, and therefore the pharmacist can do what he wants, meaning dispense the drugs according to his expertise in violation of the FDA regulations. And I'm sorry, if FDA is not the right agency here, fill in the one that would apply, but probably the FDA. It says, or if there's a law against polluting the river, if there's a law against polluting the river and everyone pollutes the river, and therefore my polluting the river will make no difference, then you can just pollute the river. You have no reason, because again, in both of these cases, his claim is that the reasons behind the law don't apply. And I think that when he says this, and again, this is a longer argument, that it ultimately becomes impossible for him to add, for his theory to ultimately add up to what he wants to add up with, which is you could still have an obligation to obey the law in some cases. And I just think it can't work. I think he's talking about expertise and advice and not obligation. The last thing I will say about, and so there's a way in which I think maybe you could come back or let other people get in, but you could come back with a critique and say, oh, I see what you're doing is you're just now like reaching to a second order thing, which is say that the problem with Raz's, I'm in trouble. Like the problem with Raz's analysis is that it's too narrow, is that he just stops at that first order level of like, does the pharmacist know better or not, or does the pollution make a difference or not? But he doesn't consider that second order level about the way in which my obedience to the law in the face of the inapplicable reasons is also part of the common good or something like that. And I think if that's where it all ends up, I think I'm okay anyway. Which is to say, if what's missing from, I think I could not okay like I'm right, but like maybe, but I can sleep at night, right? If the difference ends up being that the people who are wrong about the law are wrong because they overlook the importance of obeying the law with respect to our obligations to the common good, all right, then I think I scored a point, even if maybe my critique isn't as earth-shattering as I'd like to believe it is. But yeah.
Matt Frank?
Thanks, Danielle. It's great to have you back at Princeton.
It's great to be here, although I'm extremely afraid.
I want to help you out with Jim Stoner and Adam McLeod and suggest that your argument echoes a good deal of Blackstone, who begins the commentaries on the laws of England this way. Law, in its general and comprehensive sense, signifies a rule of action. Okay, there's your rule. That sounds like heart. And is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. He gives examples of laws of
he knows how to go on.
Gravitation, right?
Yeah.
And then he says, and it is that rule of action which is prescribed by some superior and which the inferior is bound, obligated, to obey. He elaborates a more confined sense of this in the next paragraph, second paragraph of the work. He says, laws in their more confined sense denote the rules not of action in general, but of human action or conduct, that is, the precepts by which man, the noblest of all sublunary beings, a creature endowed with both reason and free will, is commanded to make use of those faculties in the general regulation of his behavior. This from the great expositor of the English common law.
Yeah.
And later he has to figure out how the common law fits into that definition.
Well, that was what I was going to, it's like, well, put that on my gravestone, but also...
That's a few pages later, but I suggest maybe looking there for some support.
Right. So,
your position.
That is, and thank you for sharing that very famous and important passage from Blackstone. My hesitance of relying on it is I assume until I cure some of my ignorance in that particular area, right? My worry is that it wouldn't make a dent in the common lawyer's argument just because say, well, that was a nice introduction, but then look at everything it says in this 4 volumes that follow that opening phrase, and it's like it's making a different point, right? So the answer is I wonder how we reconcile that with everything else he says, and I don't know, but it's certainly worth exploring, as you say, and I will hold them accountable. I won't have to answer any of their questions until they can answer that one for me. So thank you. Okay. Thank you for the inoculation. Yeah.
Claire.
I appreciate it.
Thank you for that wonderful lecture. Philosophically, I think I'm with my sister here. But what was coming to me, first a sociological point, the loss of orientation to the common good. I don't know exactly how you're establishing the threshold, but I'm wondering how much of the obligation to obey the law dissolves, how quickly, how widely, and how deeply once that threshold's reached. And the reason why I ask is while you were speaking, for some reason, all these passages started coming to mind from writers during the Soviet Union, from Solzhenitsyn, Vasily Grossman, and when they talk about the law, they sound like Bentham. They sound like Hart. It's a completely prudential calculus. And I think when many of the populists begin sounding like Hart, it's a sign that the orientation to the common good is in fact dissolving. It's a comment on the nature of the regime. But once the threshold is reached, does the person in the middle of the night still have an obligation to stop at the traffic law? the traffic light. I think there's a couple reasons why they do. And so I'm wondering how much of that obligation is just vanishing, poof, once the threshold is obtained.
Yeah, so, I mean, well, sorry, can we keep the microphone there for Christy? Would it be all right just for 1 sec? Because I wanted to ask what you think the reasons are. That might be like very material. It's like what, yeah. But let me just say a word so I don't forget two things. And then, so first of all, we could say that the Soviet regime at a certain point, that's just a bottle of poison with the label medicine on it, right? Like there could be a conceivable regime in which, now I'm a little bit careful about that because I didn't say it. I'm afraid I'm prepared to make the claim that at least for some people under the Nazi regime, there's still, for the people whose common good was contemplated by Nazi law, there could still have been, and it's like a little bit complicated, but there could still have been a prima facie obligation to obey the law. Of course, in the more severe cases, stronger competing reasons not to. Okay, I know we're not arguing about that. So that's the first thing about the Soviets. I definitely do not have an answer for like the, how broad, how deep, how, but I to be consistent with my theory, I think I would need to say that there would be somewhere across the line where you wouldn't have to stop at that traffic light anymore in the case of the mythical traffic light. Now, as I was careful to say, you always have a duty to exercise due care going through the intersection, right? But the traffic light at that point would be meaningless, right? It would be like, I'm going to stop and look and go when it's safe. Now, Finnis has made the remark that there's always a reason to do it. And the reason to do it is that if you make that judgment at 3 a.m, you might make that judgment at 3 p.m, right? You're going to get in the habit of, and I fully respect that. And I think for the case of the mythical traffic light, we have to factor that out. But again, like that also reduces us to thinking about like what I'll just say are like very prudential reasons for like, I have a hard time seeing that adding up to an obligation to obey the law. Now, again, going back to what we were talking about before, I think maybe this is related to your question. There's a point to which, and I know Professor George will get, this is, like my failings as a student, not his failings as a teacher. There's a point at which the distinction between obligations and reasons vanishes, right? Where obligations just are conclusive reasons and so on. And so I don't know that I can sustain this distinction indefinitely, but I do think there still is something important, and maybe I need to develop it more, but there still is something important in this distinction between having good reasons for doing something and having an obligation to do it. Now, again, the closer those good reasons come to conclusive reasons, I'm in danger of losing the argument, but that's anyway. But so yeah, I just wanted, and sorry, but I just wanted, when you said I think there still might be reasons, because I might just agree about those reasons, but not think it changes the rule that I'm trying to, yeah, sorry. So what were the reasons? Or that sort of thing? So,
you have, in reaching for Finnis, I think that you put your finger on the passage that was occurring to me. I would just encourage you, Daniel, the real world examples make establishing a threshold for the dissolution to obey all laws incredibly difficult. And I think if you study them in a granular way, I think that'll be like an automatic kind of feedback loop to nuance some of those areas.
Okay. Thank you.
I'm going to hand the microphone down here to...
right in front of you. Ma'am, you were waiting as well? Is that right?
Mm-hmm. I'm just wondering, when there are public good ideas that are so divergent, like abortion, like where did the legal scholar go to try to figure out what the public good actually is? Sure.
Thank you. And that, of course, is a very difficult question. And the first answer is, I might ask maybe to clarify a little bit, but the first answer is to the natural law, right? So the first question that we have to answer, here's how I would explain it. All of our decisions, and this is like kind of everything from like really important stuff to like what should I do for lunch, is going to kind of be a mix of principled and prudential judgments. And step one is the principled judgments, where we look to the natural law, or more broadly for others who are not natural lawyers, to philosophy,
to see what the boundaries of justice, where's the line between justice and injustice, because all of our choices, all of our legitimate choices, our acceptable choices, have to be on the side of justified, of just, on the side of in line with and not in violation of moral principles. So there's going to be a range for any question, there could be a range of permissible options, and then within the range of permissible options, we'll have to use wisdom, we'll have to use judgment to make prudential decisions about, kind of in a little bit crude way to put it, but the cost-benefit analysis of what are the competing goods in each choice, and how do I decide between them. But again, to emphasize, all of those are judgments only within the parameters already set by principles of justice, already set by morality. So in a case of, and that analysis would follow even like a question with abortion. So someone, and again, there could be the question of whether to procure or perform an abortion on one hand, or is one set of abortion questions, or what the law should do about something like that. And again, we could kind of, not to minimize all, but kind of plug and play different issues, right? You could ask something kind of out of our political realm, that's like cannibalism, right? But kind of ask, or you could ask something in our political realm, but less emotionally charged, like maybe environmental regulation or tax policy or something. And the same basics would apply in the sense of, first, there have to be moral parameters set, such as what does the natural law or whichever philosophical school we subscribe to say about the morality of this act. And it's going to tell us that this act is either morally required, morally permitted, or morally forbidden. And if it is morally required or morally forbidden, then the prudential judgments don't really have to come into play as much, because, right, so Antigone has to bury her brother, right? Just no choice. She's got an obligation to the gods, to the higher law, to bury her brother against the government's decree. And there's just no two ways about it. Alternatively, the act could be forbidden, right, to commit. So I'm really hungry, it's time for lunch, but I can't eat my student. Well, it's not, but it's like as appealing as that might be, counterfactually, not appealing at all, happy to say, but right, but that's already just ruled out, and like all those prudential judgments about I get an upset stomach, and like how expensive is it, like the normal things I do when I choose lunch, right, don't come into play. Then there's that middle ground where I don't know, filibustered all the way to the end here, but where there's that middle ground where acts might be permitted, and then we have to make judgments about well, given that the act is permitted, is this something that on balance I should or shouldn't do? And then again, and same analysis kind of with the law would be, is there some moral requirement to have the law one way or another in abortion, or is there no moral requirement? Then it's kind of, we have to make judgment calls about all things equal, what's the best law for the sake of achieving the moral principles we're after, and so on. And so, and just the very last thing on that to say, if it doesn't escape my mind, it's just that. So therefore, on the question, yes, right, all of it has to start with the question of the moral principles, and the obvious ones at play here are either there's a right, a woman's right to autonomy, which means that there's a requirement for the government to permit her to proceed without interference, let's just say, or alternatively, the child has a right not to be killed, and therefore the person has a moral requirement not to commit an act otherwise, not to kill the child, and or the government has an obligation to protect the child, which again might, and those two things don't have to go together. You could believe both. Let me just leave that there so that we can still give somebody else again one last question. Yeah.
There's a question over here. Yeah. Mm-hmm.
A couple of quick examples from a layperson's point of view. I respond to your notion of the law as a command and my obligation. But getting to your red light example, 57 years ago tonight, a little bit before midnight, I waited at a red light in Red Bank, New Jersey. And I waited.
It's always Red Bank, yeah.
And my wife sitting next to me said, "The contractions are coming closer. I think we're gonna
But what did you do? What did you do?
go." So I had an immediate answer to what to do. But
Wait, but you still didn't tell us if you ran the red. If you ran the red.
There's another example I'd like to offer.
Taking the fifth.
I'm hard of hearing. I didn't understand the question. So, in September of 1943, word leaked out that the Gestapo were about to round up the Jews in Denmark. And the Danish bishops, within 48 hours, issued a pastoral letter which laid out in detail from Scripture, both the Hebrew Bible and the Christian Bible, the reasons why Christians were obligated to protect the Jews, not the least of which they noted Jesus was born of a Jewish mother. And at the end of that letter, they said, we recognize our obligation to be obedient to authorities above us. However, if the question is, shall we obey man or shall we obey God, we shall obey God. And so I think the overriding issue on when to break these laws turns on the question of mercy, do justice, love mercy, walk humbly with our God.
Yes. No, thank you. 2 lessons. Absolutely. 2 lessons from tonight. Stop at red lights and hide the Jews. Thank you.
Before we close, and I'm so sorry that we've run out of time, Daniel, I just want to ask a question of my own. I'm hung up right at the beginning. Now, maybe I was brainwashed by my teachers, who, of course, were Hart's students, Professors Raz, Finnis, and Dworkin. And although I wasn't taught by Professor Hart himself, he was still sitting in on the seminars that Professors Hart, Raz, Finnis, and Dworkin were holding at Oxford when I was a graduate student there in the early 80s. But I don't see what's gained, and I see a lot that's lost by insisting that even what Hart calls power-conferring rules are, in some fundamental sense, commands. I don't see why you need that. And it seems to run straightforwardly into the problem that matrimonial law, trust and estate law, clearly consists of a body of rules that don't seem to fit the description, aren't captured by the word commands. So why are you insisting on that?
Well, thank you. I mean, part of the motivation is that the distinction is an important part of Hart's reason for throwing out commands in the first place. So Hart is going to, so if I want to say that law is command and Hart doesn't, Hart is going to say, unless you can show me that power conferring rules fit command the way duty imposing rules fit command, you can't use command. So I can't revive law as command without showing that power conferring rules are a species of duty imposing rules. But also, I think it might be, it's not just strategic. I think the pushback is important for getting back to the truth of the matter. I think at the very least, I think that they are that power conferring rules are a species of duty imposing rules, because I think what they're really saying is, or a conditional command, that if you want to do this, this is how you have to do it. And I think that actually is, I think Hart is actually missing what's going on. Like Hart suggests it's kind of just like a permission or something like that. And I actually think he has an incomplete view of what a power conferring rule is. And that the government is actually, it's giving instructions. Now it's only giving instructions for those who opt in, but for those who opt in, it creates a set of duties, just like I think actually
Congress has a duty to pass laws according to the procedures set up by the Constitution. Now, they don't, if they pass laws. Again, now they don't have to pass laws, but if they pass laws, they have a duty to do it in that way. And it's not just that, well, we have the power to do it like this, but we're going to just do it like this instead. I think those are the main reasons.
But do you resist the idea that law is a body of rules?
If you're comfortable using the rules in that context as synonymous with commands.
Okay.
Daniel, a conditional command is not a command, and power conferring rules are conditional. If you want to get married, you need two witnesses.
You need to. Yeah, that's.
It's what we would call, I think, they think the English word that would capture it better is it's a hypothetical. In other words, if then. So here is the method. We're going to give you a mechanism for making a contract that's binding. We're going to give you a mechanism for transferring your property to those to whom you'd like to transfer the property upon your death. And we need a set of, I don't know any other word than rules, right? We need a set of rules to facilitate you accomplishing something you want to accomplish, where it's not between you and the government. It's between you and your fellow citizens, you and those who will you'd like to inherit your property, you and your contracting party. He wants to give you 50 widgets in return for which you give him $50. And vice versa.
Okay, so if that's right, then can I force you into saying that every affirmative, not negative, but every affirmative duty imposing rule is actually a power conferring rule? So you don't have to earn any money, but if you earn money, then you have to pay your taxes. And you don't have to expel any sulfur particles out of your smokestacks of your factory, but if you do, then you have to limit it to the following amount or do it in the following way.
It's the logic to put the ought and the if ought are separated. You tend to use it in the parentheses.
Okay, but then are you agreeing then that the affirmative duty imposing rules are power conferring rules in the conditional way that you say?
You ought not to care.
No, then that's a negative, a positive one. A positive power, like drive on the right side of the road. Right? So that's no longer a duty imposing rule. That's a power conferring rule that just says, if you want to drive on the right. Or same with tax, pay your taxes. That's conditional. You don't have to earn any money. If you're employed and you earn money, then you have to pay your taxes.
That's not correct. That's not a power conferring rule.
But why not? On your logic, isn't it? Why not on your logic?
Getting married, activities you want to do within the legal validity. So
getting
in
a job.
Way, I mean, Finney says this, and he's correct. The law is a moral technique.
Okay.
So it's giving you conditions to realize what you want to do ethically and morally.
Right. I'm asking yes or no.
It
doesn't
affirmative give you legislative power.
Yes.
So the power conferring rule gives you legislative power.
But I'm arguing that legislative power is a form. It's a duty to act in a certain way if you choose to act in that context.
No, you want to accomplish a certain goal, right? And you can change your legal relationship to another private citizen. Right at the moment, you don't have a duty to give me $50. I don't have a duty to give you 50 widgets. But now you and I together, acting on power conferring rules, can now change our legal relationship. We can change the law so that now you owe me $50 and I owe you 50.
But you have a duty to do that in a certain way. You can't. It's not up to you how you change the legal relationship. Right? The law specifies the way in which you need to change that legal relationship.
It empowers you to do it, to do something you want to do.
It gives you a duty to do it in that way.
Yes.
No. Okay. Well,
okay. So,
we've gone over, but please join me in thanking Professor.